Welcome to True Crime Boss. I'm Jarrett Ferrantino. We're talking about Bryan Kohberger again. The latest developments in the case, as we predicted. The defense was back in court asking the judge to reconsider their motion to throw the indictment out. That's done, folks. It's time to get into capital litigation. You are going to start hearing significant items and facts we have not heard before. The defense claims they're working very hard every day. The prosecution claims the same. I've done capital litigation and large prosecutions like this. They take over your life and take a significant amount of time to get to trial. I was not surprised that the judge moved this trial, which he acknowledged the reality is into 2025. In all likelihood, folks, this trial will happen in the summer of 2025. Here's what we heard, and here's the significance of what we heard, if I can break it down for a little bit of the inside baseball of what was going on in that courtroom. The majority of the argument was controlled by the defense, and their argument in front of the judge pleading for more time. And what are the things they said? They claim there are now 51 terabytes of information that they have to go through in preparing their defense. There's 400 witnesses that were interviewed. They claim they've only talked to 10% of those folks. They also claim that pretrial publicity is having a chilling effect on those people and their willingness to talk to the defense. They also claimed that they have a mitigation expert retained and they have to get to work on that. These are all of the things that a defense team has to do in preparing for capital litigation. Now, I don't doubt the sincerity of what the defense team is arguing. This is not justice quickly. Everything that was said by the defense team and Ann Taylor that day is true. This is a large file. And 400 witnesses, they have to try to talk to those witnesses. Now, folks, those 400 people, they don't have to talk to the defense. They don't have to talk to anyone. But the defense has to have the time to send their investigators to try to interview them. One other thing Attorney Taylor said was they have more than 9,000 pages of reports that other tips came in from around the country regarding who may be responsible for the death of our 4 beautiful victims here. This is a surgically precise process. Everyone out there is saying this trial shouldn't be delayed. This trial needs to happen. Something else Attorney Taylor said in that courtroom. She said, Judge, if I don't get to do these things, I'm going to be ineffective. It was a quick comment she made, but in the lawyer world, that's a bomb, folks. You cannot have an ineffective defense attorney in a capital litigation case. Those are buzzwords that when the judge hears them, he says to himself, oh boy, I have to think about what she's saying. And if you saw this hearing, the judge nobody was lying. Even the prosecution is acknowledging they're giving the defense everything they have when they have it. The defense attorneys weren't blaming the prosecution. They said, look, we trust they're giving us what they have when they get it. The problem is we have to get through it. So everyone is in agreement on that. Everyone is in agreement that this is a massive file. This rush to trial is only going to result in having to do this trial twice. The court, although he acknowledged he was moved and felt for the victims' families, he is the umpire. He cannot be moved by the public's desire to have a fast trial and a convenient trial this summer. He has to call it straight. He has to consider what's being said. And when a defense attorney says, I'm going to be ineffective if you don't give me more time, then folks, that judge has to seriously consider it. So I really believe that the defense is being sincere in saying they need more than a year to get ready. The other thing, if you read the tea leaves here, the state, although they can't just come in and fall on the sword and say we all need more time, was hedging that argument a little bit. They agreed that the file is large, that this is going to take some time, and the reality is they may not be able to do this summer. Then they said the only time we can do this is in the summer for convenience of hotels and parking. I got to be honest with you, folks. I don't get this part of what they're saying. I don't get this argument that I'm worried about where the media is going to park. listen, if the lawyers have a place to park and the jurors have a place to park, and I'm sure the judge has a reserved parking spot, let's get it on. Let's get it on in Idaho, okay? Let's not worry about inconveniencing the town. The reality is, whenever this happens, it's going to be Super Bowl week in the media world and Radio Row in the media world and the podcast world. That's just how it's going to be, whether it happens in June or January in Idaho. So I don't see why they're limiting themselves to the summer. The defense argued about the size of the file and how much time it's going to take to get through it. They also, for the first time, acknowledged they've retained a mitigation expert. That means, folks, there is an individual working with the defense that's going to reverse engineer Bryan Kohberger's life. In a capital case, there's 2 phases of the trial. If Bryan Kohberger is convicted of these killings, the second phase of the trial begins, which is essentially a new trial in front of the same jury, where factors supporting the imposition of the death penalty will be considered and argued by the prosecution, and mitigation factors in support of saving Bryan Kohberger's life will be presented by the defense. That's done through an investigation and the testimony of a mitigation expert. We'll do a whole show on that one, but I promise you that takes time to prepare for. And that particular phase of the trial could take several weeks as well. I've been a part of those penalty phases and those types of trials. They take time. They're emotionally trying for both sides. Very difficult, but forthcoming in this case, and something that hasn't received a lot of attention, but is certainly coming down the tracks. In addition to the volume and the retention of a mitigation expert, we finally started to get the telegraphing of what motions may be coming from the defense. So far, this whole thing's been about trying to get this grand jury indictment tossed and all this, quite frankly, bullshit. Everybody knew these weren't going the defense's way. We have not gotten into the real crux of this case. That's coming. And how is that coming? That's coming in pretrial litigation. And folks, this trial basically begins in that process. Everybody's working real hard, even though it's not being done in front of a jury. Trust me, major litigation happens before that jury selection process even begins. One motion the defense already acknowledged they're going to file is a motion for change of venue. We'll do a whole episode on that motion when it comes. But what that simply means is they do not believe, the defense don't believe, that Latah County can conduct or hold a fair trial for Bryan Kohberger based solely on the press that and in the amount of press that this case has received and essentially convicted Bryan Kohberger in the court of public opinion. They will be asking for a change of venue. Folks, you can't conduct this trial on planet Mars without people knowing about it. Let me say this. The answer to whether or not a trial can be conducted in a particular jurisdiction really is best found out or determined when you're picking that jury, when you start asking people. If I'm a prospective juror, if I know about the case, and you have to be living under a rock to not know about this case, quite frankly, if you don't know about this case, I don't want you on my jury because you have no clue what's going on in the world. The question is really, A, do you know about this case? B, have you formed an opinion, an unshakable opinion, essentially, as to the guilt or innocence of Bryan Kohberger? And C, would you be able to fairly consider the law and evidence provided from the court and the defense and prosecution teams in assessing Bryan Kohberger's guilt or innocence? If people could say, look, I'm aware of this case, I know what it's about, I know that this man was arrested, but I really don't know much more beyond that, or I'm willing to keep an open mind, you could be a possible juror. I am sure there are enough people in Latah County or the surrounding communities that could be fair. We argue about this stuff every day. I look at the comments below this episode. You'll see people arguing for and against Bryan Kohberger's case. So we know the motion for a change of venue is coming. We're going to dedicate an entire episode to that. Really, folks, what I gleaned from the defense argument last week was They're saying it's not going to be a 6-week trial. It's going to be a 12-week trial. That means they are preparing to meet the prosecution at every pass. If the prosecution puts up an expert, they're going to put up an expert. If the prosecution conducts an extensive examination of a particular witness, the defense will be prepared to cross-examine that witness extensively. I believe, having done these types of trials, this will be more likely a 10 to 15-week trial. With the penalty phase and the jury selection all factored in. I think that that's closer to a reality than the ambitious prediction of the prosecution of 6 weeks. That's assuming nobody gets cross-examined and everything goes their way and there's no legal issues that come up. And that's just not going to happen. One of the other things that the defense raised that I thought was a little curious to me, they said that people are hesitant to talk to them, and that 400 interviews have been done, or 400 witnesses have been interviewed in the case, and they've only gotten to 10% of those people, and people are being hesitant to talk to them. The reality is, folks, you don't have to talk to the defense lawyers. And pushing this off to the summer of 25 or the summer of 27 is not going to make those people any more likely to talk to the defense team. So I thought that argument kind of fell flat. If I was the judge, I would have said, how is a delay going to benefit you in that regard? One other facet of this case that's getting a tremendous amount of coverage, and I've been watching very closely, is Gonsalves family and the victims' families are releasing statements really critical of the amount of time this is taking. Folks, there is a breakdown of communication here between the prosecution and the victims' families. The way I've typically done this is I bring the victims' families into a meeting with the members of my prosecution team. I sit them down. I tell them exactly what's likely to happen in these hearings. I tell them why these things are going to happen, what to expect. Based on what I'm seeing in the public statements that are being made by the victims' families, that's not happening, and I'm not sure why. It's not a violation of the gag order to meet with the families and provide them with an update and what to expect in court. And if properly explained to the families, they will understand the following. This matter has been thoroughly investigated. Their children's deaths have not been in vain. The individual responsible, in the eyes of the prosecution, and quite frankly the evidence, is sitting in a jail cell awaiting trial. The case never went cold. These things take time. Everybody is working hard to get justice for your children. You need to be patient. You need to understand that the longer we have to work, the better chances we have to successfully prosecute this case. And you also need to understand that Mr. Kohberger, under the law, is entitled to a defense and a defense team that's prepared to defend him. The question you have to ask these families is this: would you rather us have to do this more than once, or do this 5 years from now again because they weren't provided adequate time to prepare and lodge their defense? The answer to that is absolutely not. Nobody wants to do this twice. These families need to be informed. They need to be encouraged that and encouraged to understand that that's what's happening here. Nobody is standing still. Because we're not in front of a jury, it doesn't mean this case isn't moving forward. It moves forward every day. Every major capital case takes years to get to trial. If it took under a year, under 2 years, it's an outlier, folks. And it certainly didn't have the kind of evidence and the technology involved in this case. It just didn't have it. I've never seen it in my career. I've never seen it in the cases out in the public that I've followed. I understand the hell these families are going through. I know so many families that have gone through it and are going through it right now. But I promise you, if it's explained to them exactly what's going on here, you would not have the families coming on television essentially lost in this process. And that's concerning to me. These families, I know they have separate counsel, but they are well represented by the prosecution team here. This prosecution team has been straightforward. They have run a great investigation, and they are open and honest with this judge. It's clear. I'm watching these proceedings. If I'm critical at any aspect of the prosecutors in this case, it's clear there's a wall between them and the victims' families in this case. It's something that they should correct. And it's an important aspect of moving forward. We're going to continue to cover the case. We're going to break down the motions as they come in. Things are going to get very, very interesting now that we've cast aside this nonsensical motion to have the indictment thrown out. Now the real litigation begins, and we're going to cover it.